So I just invite the speakers to come and take their seats. Arvind Narrain will be chairing. The speakers include Mohsin Alam, Nizam Pasha, Aymen Mohammad, and Justice Swaminathan. So I request all of you to take your seats. And then I'll simply hand it over to Arvind to start the session where we want to look at the current debate on citizenship. I think whatever you're comfortable with, yeah. Just, open in two. Yeah. Otherwise, it doesn't capture the sound.
Sure. Yeah. Hello, everybody. Yeah, we're here for the panel which will go and look at the CAA, NPR, and the NRC debates in the country. Obviously, they've been of great relevance and moment for everybody in this room and everybody really around the country. And what we hope that we get during the course of this panel is we get to shed a little more light on some of the complexities and the nuances around these issues and why they matter so much. For that, we have an excellent panel before us. I'll just introduce the four speakers, and then we'll proceed directly into the session. First, we'll have Justice Swaminathan, who is very well known, at least in the NALSAR context. And I think we know him, of course, as a judge of the Madras High Court. And we also know him as someone who's very interested in the sphere of academia. You've seen him for the last one day and even the last year. He sits and listens intently to all that is said in the course of these proceedings. And we know that what he hears during the course of these proceedings become a part of his worldview, and we hope and sometime become a part of the way he thinks and delivers his judgments as well. So we really welcome him on that particular point. The second speaker will be Aymen Mohammad, who is a PhD candidate at the NALSAR itself, and he will explore one particular dimension which I think is a crucial moment, which is the entire issue of what is the obligation of states to enforce union laws, keeping in mind the idea of the preamble and the preambular promise of fraternity. I think that's what Aymen is very interested in looking at, and we look forward to hearing what he has to say on that point. Then we have Mohsin Alam, who is an assistant professor at the Jindal University and a former alumnus of NALSAR itself. And he's also a co-founder of this initiative called Parichai, which is a legal collective which aims to provide legal representation to persons at risk of statelessness. Again, he's done a lot of work in the context of Assam, so he's going to tell us a little more of the Assam NPR NRC process and its implications thereon. And we'll end with Nizam Pasha, who is a practicing advocate at the Supreme Court, and he will address a little bit of the role of the Supreme Court in the entire NRC CAA process. Without further ado, I'll hand it over to Justice Swaminathan, and I think we have a time of 15 minutes per speaker.
Good morning to one and all. Since everybody is training their guns on CAA, I offered to play the role of a devil's advocate. Arvind was a little scared yesterday that I may stir the proverbial hornet's nest. Friends, my engagement with this issue of citizenship took place sometime in the middle of last year. A group of Sri Lankan refugees had filed a writ petition way back in the year 2009 seeking citizenship. You won't believe, for 10 long years, neither the state government nor the central government filed any counter, no written response. So I insisted. In fact, I had to adjourn the case on at least 3 or 4 occasions just to make them file their counters. And ultimately, when they filed their counters, I found that the stand of the state government as well as the central government was one and the same. For all the shedding of tears by the Tamil Nadu government, it took the stand that for someone to get citizenship, either by registration or by naturalization, one must not be an illegal immigrant. And Act defines an illegal immigrant as somebody who does not have a visa or a travel document. Since they do not fulfill even the threshold condition, their application for grant of citizenship will not even be considered. That was the stand taken by the Tamil Nadu government. I felt aghast. See, these persons hail from Tamil Nadu. In fact, they could even name the village from which their grandfather or great grandfather hailed from. They went there as workers in the tea estates of Sri Lanka. And all of us know, post 1947, ethnic riots broke out, and to save their life and honor, they had to take the ferry boat and rush to India. And they have been housed in camps for more than 30 to 35 years. I think the current fashionable term is detention center. In Tamil Nadu, we call it refugee camps, not detention centers. And the conditions of the camp are hellish. So I said, this is just not fair. They are not going to be sent back to Sri Lanka. They are not going to be observed here. And where will they go? It is like Tirisangu Swargam. And therefore I felt this condition of statelessness is a clear infringement of their right under Article 21. I held Article 21, which applies not only to, it applies to citizens as well as non-citizens, to asylum seekers, to refugees, to everyone. Therefore, I said the petitioner's case for consultation has to be considered. In fact, I almost granted them final relief, but then I thought my order may be reversed either by the division bench or by the Supreme Court. Therefore, I decided to play safe and stopped at some level. And this is my judgment in Ulaganathan versus Union of India. And therefore, I was deeply disappointed when the present CAA did not include the Sri Lankan refugees. Last evening, but at the same time, while observing the nature of engagement that is now going on, I do feel constrained to say that whatever sentiments that are expressed by the proponents of CAA, you would find them expressed in a far more aggravated terminology and phrases by some of the members of the Constituent Assembly. In fact, Manav Kapoor referred to that in his presentation last evening. But I want to draw your attention to what Dr. Ambedkar said in the Assembly. He said, we are not here to make a permanent law of citizenship. No, that is not our job. That business is left to the future parliament. And that is why Article 11 says Articles 5 to 10 will not derogate from the power of the parliament to make any law, I underline the word any law, regarding acquisition, termination and for matters connected with citizenship. That is what Ambedkar said. Therefore, I feel the legislative competence of the Indian Parliament to make the amendments, that can't be in any doubt. Of course, I am sure some of you would have listened to Suhrit's and Harish Salve's presentation in either Times of India, Times or NDTV? India Today TV. See, there I would request my young friends here to see the presentation of Harish Salve in YouTube. I don't repeat the same reasoning. He says this amendment, the CAA will not fall foul of Article 14 or Article 21. And I would fully concur with that reasoning, and I would request you to see for yourself. And of course, Surit's strong response also to that. But my primary purpose here is only one thing. See, we must engage See, both the sides. See, as a judge, I should not use the word we and all. I'm not supposed to take sides. There must be a proper engagement. See, I'll narrate one story. Of course, I can't vouchsafe for its veracity. All of you have heard of Justice Markandeya Kadju. I'm told he would always address the council only in Hindi. And the situation was becoming so intolerable. Therefore, some people went to senior counsel Rohinton Nariman. Of course, you can put it in the bracket, the obsequious as his lordship then was. And he said, okay, I'll take up the matter. And after listening to a long question put by Kadju in Hindi, he gave a long answer in Gujarati. And that was it. And I'm told Kadju got reformed from the very next day itself. But what this story illustrates, see, there must be a conversation. Otherwise, there can't be a community. Nothing, even for a confrontation to take place, there must be some common ground. Therefore, I feel the persons who are opposing the CAA must understand the psyche, the worldview of the proponents of CAA. I'll just quote 3 or 4 sentences. Don't get offended. Just listen to it alone. 3 points. First one is 1947, August 15, January 26, 1950. To this group of people, and they are very strong in number, to them, the Indian state was formed during this period, 47 to 50. According to them, the Indian nation predates the formation of the Indian state. So the distinction between nation and state, that is very strongly made, and I think it's important that those who are opposing CAA must appreciate this distinction. Point number 1. Point number 2, the emotional aspects. Even when Janaganamana is sung, they will stand up, erect, stiff, respectfully. But when Vande Mataram is sung, their heart melts. 3 and last. To them, India is not a constitutional formation or entity. It is Bharat Mata. And they are not able to come to terms with the vivisection of Bharat Mata in the name of religion. So this being their worldview, I think unless you get into their psyche and understand, you will not be able to engage with them. And I believe it is possible to engage even with this group by invoking the concept of Akhanda Bharat. See, personally, I am a follower of Joseph Carles Kumarappa, who was a greater Gandhian than Gandhi himself, an uncompromising Gandhian. To me, it is Joseph Kumara who is an icon. I just assume, if he were in this position, what he will do? He will talk in the language of Akhanda Bharat. He will say, people all over, they are also our people. How you can distinguish between people and people in the name of religion? Merely because they are on the other side of this Radcliffe Line border, how will they become somebody else? I think it is, see, as a strategist, I would believe it would make greater sense if the cause of Rohingyas, with the cause of Ahmadiyas, with the cause of Sri Lankan Tamils, if that is taken up first, and I think that will advance the cause of, I think as a matter of strategy, I am suggesting. And certainly Pasha will agree with me if I say that a law cannot be struck down on the ground of under-inclusion. See, the parliament will have the final say when the matter of conferring benefits. A, B, C, those 3 groups are given a benefit. If D group is denied a benefit, on the ground of under-inclusion, see, you may say it is exclusion, but the court may ultimately hold it is after all a case of under-inclusion, and they may refuse to take down the law. Therefore, to advance the cause of secularism, love and tolerance, in which I firmly believe in, I believe a different mode of engagement is called for, and this I thought I should make clear in my presentation. Thank you.
Hi.
Hi.
Um, uh, I'm going to be looking at one very specific component of the CA, NRC, NPR issue, which is the refusal of states to enforce union laws, parliamentary laws. In this case, it's slightly different because the two states that have refused to enforce, West Bengal and Kerala, have refused to enforce the NPR. Statements by Chief Minister saying that one doesn't have to worry about NRC is not something we can really assess against a constitutional text. But these two stay orders are slightly similar in the sense that they are made as a circular, and they are at a very low level of official government functioning. More importantly, NPR is not a law made by Parliament. It functions solely through rules made under the Citizenship Amendment Act of 2003, which is actually the motherlode of the Citizenship Act of 2019. The key difference between NPR and any other law made by Parliament is the fact that even the Citizenship Amendment Act of 2003 does not discuss it in any detail. So this is completely a creation of the union government, of the executive, without an express power delegated to it to conduct this exercise. Now, should I go through the NPR rules once, or is everyone familiar with it? Yeah? Okay. Very quickly, under the Act, you have the 2003 rules. The 2003 rules look at three things. The first is the enumeration exercise known as the Population Register or the National Population Register. This is then used to create a second procedure, which is known as the National Register of Indian Citizens, or more commonly known as NRC. And the third procedure is the issue of NRIC cards to citizens. Now, this is something that was very frequently confused with Aadhaar by Chidambaram once upon a time. But the NRIC cards are back in discussion. Amit Shah has mentioned it a few times that we have too many documents apparently, and now we just need one card that will also work as a passport, which is slightly doubtful. But this is NPR in a nutshell. Now, what it actually does is, unlike the Assam NRC, the NPR's purpose, the sole reason why you are being enumerated, is so that your citizenship can be verified. There is no other reason why a household enumeration has to be conducted. And especially if you look at the rules, the sort of questions that are being asked, they're all geared towards knowing who you are and whether you can definitely prove your Indian citizenship. There is no other purpose for the NPR as such. Now, the union government has repeatedly said that they need this information because they're going to develop schemes on that basis. So NPR has some questions regarding the number of toilets a household has, or the number of rooms a household has. All of these questions are already answered by the National Family Health Survey, by the National Sample Survey Organization reports, and also it's not a very difficult thing to collect data or collate data on these grounds. But the key with NPR is that your data is not anonymized. So it is possible for one local jurisdiction, everyone would know who's on the list and who's not. Now, this basically means that I can be identified at a level less than even a city, so a zone within a city possibly. In villages, it will mean that you will be able to identify whole families, you will be able to identify that one family that does not belong to your community, and it makes exclusion easier. But more importantly with the NPR, what is not very frequently discussed is the fact that this is not individual. It's not counting you as a person, it's counting a household. So it's completely possible that you may say kagaz nahi dikhayenge, but your head of the household, which is mostly going to be the father or the male in charge, can report you as a person who has to be listed, and you're done. So again, the amount of discretion in the second component of the process is a lot, which is about which is about enumerating and identifying citizens. Now in Assam, what the case was that all of you were required to go file documents to prove your citizenship. Here the burden of filtering citizens is on that local Babu, who is to be designated or appointed by the state government. Now this is a very important part, because if a state government is appointing an officer, then necessarily these are people who are going to come from the state administrative services, and the description within the 2003 rules clearly explain the sort of position that this officer would be holding. Now, when we look at this information together, what we basically have is a procedure that is requiring this local officer to go through this list and mark out people as doubtful citizens. Now, these people are going to be issued notices who will have to then explain how they are citizens or not citizens. Now, if you think your problem is solved and you're included in the list after this doubtful citizenship exercise is over, it's not. A draft list is published in your local area, and literally anyone can object to your name's inclusion in that list. Now, these are the NPR 2003 rules, so I'm not making this up. You can go check it out. It's still on the website, the Ministry of Home Affairs website. Now, this basically means that for an officer, filtering is not only a discretionary job, but also one driven by mobs or driven by groups with prejudices. There are no checks on who or why someone can file an objection. In Assam alone, there were 3 lakh objections filed before the objection deadline. These included objections over children who were included, 8-year-old kids. So you clearly know where this is coming from. It's not very easy to fill out standard forms and push them through a digital platform. So yeah, this is the broad idea. This is the broad logic of why states decided to these 2 states decided to stay NPR, because they connected it with NRC. Now, what I'm looking at is slightly connected to my PhD topic, which is understanding fraternity in the preamble, and using its meanings to interpret provisions and understand other provisions better. How is it that fraternity can help us improve our understanding of center-state relations? How is it that fraternity can provide us with new insights on how we interpret Schedule 7 and their inter-se relationship? I think there are some very important insights that we're going to gain. And one of the things that I'm looking at as part of my research is the idea of an asymmetric federal constitution. This allows diversity of not only communities but also arrangements. So you have states that have sub-regional entities, you have states that have interstate entities, and these explain a very complex sort of federal structure. So clearly, federalism is not just about having an office at a local level where the union instructs and the state has to comply. Federalism clearly is a manifestation of India's diversity and of how many communities feel part of this Indian Union and what is required, what is to be offered to them. So in this case, it's very easy for the union government to say that we have passed this law, and in this case we have made these notifications through rules, and now you're going to enforce them and implement them. States are constituent political units. Bharat, that is India, is a union of states. So if there are no states, if there are no constituent political units, then there is no union. Right now, this is very important because it tells us that states not only have a right to object and seek a remedy before court, but they also have a right to interpret the constitution, because they are working the constitution. It is not just judges who interpret and who apply the constitution. Each one of us administering or being appointed by the constitution is required to interpret it and see whether their own constitutional obligations are in place. Now, because both of these states have used public order as the basis of staying this, I would just want to get into what possible explanations could we think about it. One that I clearly see is that NPR is an undue burden not only on the state but also on its people. Because this undue burden is through an arbitrary exercise where the union has not provided enough information on why it's needed in the first place. The union isn't telling them, isn't asking the state why it is mandatory and why an officer of the state government can be penalized for not cooperating, why all of this is being done through rules. And if the union is not forthcoming, then states do have the right to at least seek more clarity before they proceed. Now, I'm just going to quickly look at you know how do constitutional provisions work out against this, and the history of the constitution with respect to federalism is very interesting, because you can clearly see in the Constituent Assembly and outside that there were very serious anxieties in that elite that India is going to balkanize. Now, India's balkanization is not only of geographical entities, but they were very worried that disparate groups cannot stay together, and this will result in what the Constituent Assembly members used to constantly refer to as vociferous tendencies. This is a very frequently used word in the 50s, and it just points to the fact that one always assumed that the states are going to be the problem. So which is why you have Article 256, Article 257, Article 355, and of course the gem Article 356. I'm going to skip 256 and 257 because there's a paucity of time, but 355 is a very interesting provision. It says that the duty of union is to protect the states from external aggression and internal disturbance, and ensure that the government of every state is carried on in accordance with the provisions of this constitution. Now, the remedy is that if a government of a state is not functioning in accordance with the constitution, then you have 356 to dismiss it and impose president's rule. But clearly our constitution makers never thought that the union could be participating or neglecting internal disturbances in a state. Clearly our founding parents didn't think that it would be possible that it's the union that may be acting in a manner that is not constitutional, and states, apart from Article 131, do not really have many remedies. So it's not interfering with the union's work, but it is also saying that we are not going to assist you right now, which is one of the only possible ways a state can function. Now, the key difference between a state and a union territory is this, that if a home ministry orders a lieutenant governor to do something, they are effectively bound to do it. There may be certain layers between them, but effectively that happens. A state is an entity with full-blown organs. It has a judiciary, it has a legislature and an executive, and it is given an exclusive scope of legislative and administrative competence, and which is why public order matters. Now, NPR is clearly going to burden people, especially marginalized people, the most, but it will also immensely burden people who are simply now have to prove their citizenship. And purely in terms of law and order, we can imagine how social frictions, how social fissures will be used advantageously through an NPR procedure. We already see it in the criminal justice system, where criminal defamation, just as an example, is frequently misused to chill free speech. Now, in this case, your citizenship is at risk. So clearly there is a possibility of a public order issue. So I do believe that when union compels the state to act in a manner that infringes on their own powers, that infringes on their own administrative and legislative competence, there is a case to be made for at least withdrawing support from the union to the extent of implementing a particular provision. Lastly, I would just like to go through how comparative federalism works in this case. And in the United States, you have a whole jurisprudence that's developing on the question of sanctuary jurisdictions. You have cities, you have states, and you have multiple levels of government that refuse to cooperate with federal laws on different, very varied issues. Now, these refusals are also not always saying no. In some cases, they are restricting it. One of the most famous, the sanctuary cities movement, was basically based on the idea that we will not cooperate with federal laws on immigration, especially where laws required police officers to find out immigrants and to deport them. Now, a lot of cities effectively have said that we will not cooperate with federal anti-immigration laws. Apart from just anti-immigration, you have pot legalization, gun laws, and various other issues on which states and cities refuse or restrict cooperation with the federal government. Similarly, on the question of citizenship, there are a few interesting examples that I wanted to discuss. One of them is community sponsorship of refugees that's very common in Scotland, UK, Scotland, UK, and Canada, going way back to the 70s, that has a 5-person rule, that 5 people can get together and sponsor a refugee. Now, the government is obligated to permit and process this refugee because the presumption is that it's that community or those 5 people who are responsible for this refugee's integration. Interestingly, in Scotland, what's now happening is that provinces are coming together to sponsor refugees and to expand on their immigration policies. So what I wanted to basically argue is that we frequently think of immigration and citizenship as questions that the union can settle a law on and the states are supposed to comply with. But there are states where, because of our history of being Akhand Bharat, there are states that have no history or documentation of people's movements. These are not small groups of people. The case of Hajong Chakmas is clearly shocking that even now, after the Supreme Court's judgments, you haven't offered them citizenship. So there is a case to be made that states need to be proactive in discussing these issues, and just because it's not a topic listed under their state list, it does not mean that they cannot raise issues on the union list. Thanks.
Good morning, everyone here. Thank you to all the organizers, Professor Chauhan, and all the student friends, Vikram. Thank you for this wonderful event, and I'm especially grateful because yesterday I had the great fortune of attending and just sitting and observing one of the sit-ins by the NALSAR Minority Forum here. And I must say it was one of the most touching moments of my life, and I'm really grateful that I was invited here so that I could attend that, and one of the most insightful experiences which I could have ever seen. So thank you. If there are people from the NALSAR Minority Forum here, I must thank you. I didn't get to thank you yesterday. Now, obviously the big debates around citizenship amendment, NPR and NRIC are in front of us, and there are big constitutional implications. The first honorable speaker did talk about the complexities of it, and I think we should engage with that question in good spirit. But I leave the question of the constitutionality of CAA, NPR, and NRIC perhaps to Nizam, who will be dealing with it in greater detail. And I must thank Aymen for introducing the procedures involved in the NPR NRIC process in the 2003 citizenship rules. What I will try and do today is, in some sense, engage with one of the panels yesterday, Kanika and Manal's panel, and think of what kind of procedures are meant to be placed in order to make this NPR NRIC process vivid. Because my concern is that in all these legal debates and constitutional debates around NPR and NRIC, there's a possibility we don't see what this process may actually look like. And in order to make it vivid, I seek to rely on the experience of very similar procedures in the case of Assam, both NRC in Assam and non-NRC citizenship foreigners processes in the state. And these processes have a long history, but over the last year, and that is the experience I'll rely on based on multiple conversations with the lawyers engaged in this process, to bring to you what CAA, NPR, NRIC really brings into existence, and in some sense I want to show you what this process will start looking like very soon if it's implemented, to make it vivid. Now, tentative operating working hypothesis really is that while others more qualified than me have argued that CAA is a dramatic step to reconfigure the nature of citizenship in India by making religion a qualification, there's something more which is at play. And I suspect that what this combination of CAA, NPR, and RIC does is that it pushes citizenship in India to the very brink. I call it the twilight of citizenship. And it is twilight of citizenship because citizenship in many ways stops being what we ordinarily understand citizenship to be, which is security of status and a cluster of rights. Rather, citizenship and citizenship processes are brought to a brink because they allow political instrumentalization of the law at an unprecedented scale, particularly in terms of targeting and surveilling people. Now, in order to rely on the history of Assam, I'll sort of quickly flag some of the key elements in the context of the state, and that's obviously a very long history, and I will not be able to go in great detail, but I just wanted to flag three things for the benefit of the audience. The first is the 1985 Assam Accord, which emerged from a great anxiety in the state, particularly among the Assamese-speaking people, that the state was being overrun by Bengali migrants, particularly in the wake of the atrocities committed by the Pakistani army in Bangladesh, in East Pakistan at that time. And in 1985, there was a broad political agreement among the Assamese students' unions and other political elements and the central government. And this is what the 1985 Assam Accord says. It has a variety of different provisions, particularly attuned towards protection of the Assamese cultural identity. But one of the key features of it is citizenship. And citizenship provision was introduced in the form of Section 6A. It is available, and currently it has been referred to the constitutional bench in the Supreme Court. And what Section 6A does is it carves out some sort of an exception in the case of Assam in potentially two ways. One, that it gave citizenship to all the migrants who had come to Assam before 1966, before 1967, and those who came between 1967 to 1971 were given a route to citizenship. So in a sense, Section 6A exists in order to facilitate citizenship for a class of people. And that one of the questions in the constitutional bench will be whether it was discriminatory to carve out a special regime in the case of Assam. The second, which also continues to be contentious, is the relationship between Section 3 of the Citizenship Act and Section 6A of the Citizenship Act. Section 3 provides a variety of different ways of birthright citizenship. So those people who are born in India before 1986 or 1987 will be citizens by virtue of being born in this country. These rules change a bit. Between 1987 to 2003, you need to have at least one Indian parent, and after 2003, you can't have any of your parents who's an illegal migrant. So Section 3 provides forms of birthright citizenship, and there continues to be a fair amount of debate and controversy about the relationship between Section 3 and Section 6A. This is significant. If I have time, I'll come back to it. And so despite this confusion, whether a person, say for example, who's born after 1987, after 2003 in the state of Assam, whether that person will get citizenship in the state even if his or her parents are illegal migrants, continues to be a controversial matter. But in actual practice, by and large, there seems to be a political consensus or a legal practice in the state of Assam which does not believe that there should be birthright citizenship in the state. So for those people who claim descent from the migrants after 1971, they will not be, even if they are born in the state of Assam, they will not be given citizenship. And this is an alive controversy. So essentially what happens in ordinary cases which go in front of foreigners' tribunals, a person has to not only show that that person is born in the country, but has to show a certain linkage, a certain legacy, a certain descent to people who were already in the state before 1967 or before 1971. And when you go to Assam, these two words of legacy and linkage essentially determine who is a citizen. Now this rather complicated, and it is complicated, and we should, in fact, considering that it's complicated, I'll come back to what is the significance of this complexity, the plethora of laws and plethora of legal regimes. The way this legal regime has been operationalized is through these things called foreigners' tribunals. Now, these foreigners' tribunals, the Supreme Court has called them quasi-judicial, but in many ways they are government committees. Their members are called members, they are not called judges. In fact, they do not necessarily even need to have judicial experience. And these FTs receive cases either through what are called references by the police. So the police can identify somebody and say that we suspect this person to be a foreigner, and that case goes in front of the member in the FT, or through a different route called the D-voter system. Now, D-voter needs to be explained. In 1997, the Election Commission of India suddenly, we don't know why, we don't know how, declared hundreds and thousands of people as doubtful voters. Essentially, when they looked at their electoral rolls, there were these big Ds written next to their names. We still do not know what the reasons for declaring people D were. Election Commission has not told us whether it followed any procedure to identify almost 3 lakh people as D voters. But once these people were marked as D, this is the parlance in Assam, somebody is called D, then those cases eventually were referred to the FTs as well. Both these police reference cases and D voter cases have gone to the foreigners' tribunals, and the foreigners' tribunals have been deciding whether there is linkage and legacy to determine whether that person is a citizen of India or not under the provisions of Section 6A. Now, what is happening in these foreigners' tribunals? The first big concern is that the burden of proof of proving who is a citizen does not lie on the state. It lies on the individual in front of the FT. This is what the 2005 Sonowal judgment in the Supreme Court, and I'll come back to that case, but in that case the Supreme Court said that the burden of proof must lie on the individual, which essentially means that when a certain individual is brought to a foreigners' tribunal, that person has to produce documents and the burden will be on him or her to prove citizenship. And what we've seen over a period of time is that the foreigners' tribunals have been relying on extreme technicalities. Names, changes in spellings of names, change in the age of the parent. All these small technicalities become central to determining who is a citizen and who is not. I'll give you one example from my recent trip to Assam, where I was talking to an FT lawyer, and he told me that he was representing this person and all his documents were in place. In fact, he had a school certificate, which is a rarity, and the school certificate had been laminated and everything was there. And documents become really important. Everybody in Assam who feels the threat of citizenship has, they'll give up their lives, but they'll hold on to that document. They're laminated. They're in these titri-tatri polythene bags. The whole life depends on that. And eventually, the FT declared this person to be a foreigner. They appealed to the High Court. They were confident. The High Court realized that practically all the documents were there. You know what was the ground for the High Court to say that this person is a foreigner? The certificate had a stamp on it, and the stamp was of a certain color. The High Court ruled that at that time when the certificate was meant to be issued, the schools in Assam were not meant to use this stamp, and therefore we refused to recognize this document. And this is, I'm just giving you one example. There are hundreds and hundreds of examples we can give. The other concern with FTs has been a perverse structure of incentives, where numerous people have just essentially suggested that FT members are expected to pronounce as many people as foreigners as possible. So that is an institutional and cultural context in which this is operating. Now, there are 3 implications which I want to draw from this, which I think will be a learning experience as we move ahead if CAA or if and when CAA, NPR, NRIC are implemented. The first is a culture of fear, which essentially is that anybody and everybody can be targeted, especially if you are from a Bengali community or a Bengali Muslim community. And this has severe impact on the legal process. There are numerous cases where family members have refused to come and testify for their relatives because they are worried that the moment they do that, they open themselves to getting targeted. So one example which recently one of the FT lawyers told me was that he was representing a person, a very old gentleman, in a foreigners' tribunal, and he passed away in the during the proceedings. So he filed an application and said that, well, this person is dead, so why not the member just close the case? In the closing, the FT member said, all right, this person has passed away, we can't proceed against him, but I have suspicion about his citizenship, so all his family members now must be brought in front of the Foreigners Tribunal, and we will test whether they are citizens or not. In fact, in Assam, people who are D or people who are declared foreigners by FTs, there's some sort of a caste system which exists. People don't want to associate with them, they don't want to get married into those families because their future essentially is absolutely precarious. The second implication is, what is the implication for law? In fact, where is law in all this? One way to look at law, obviously, is the question of legality and the question of constitutionality. I would propose that we should also look at it from a law and society perspective. In fact, what I observe, and I assume many others do, that this situation is not the absence of law. In fact, there is excess of law. There's too much law. There's law everywhere. The Foreigners Act, Foreigners Tribunal, Foreigners Rules, Foreigners Tribunal Order, Citizenship Amendment Act, NRC, Supreme Court, legacy documents, list one. Anybody who's studying Assam would realize that it requires a lot of time to even wrap one's head around it. And a lot of this excess of law is essentially unresolved. The Supreme Court order which initiated the NRC under Section 6A was the same bench which referred the constitutionality of 6A to a higher bench. The question of Section 3 and its application, which has huge implications for people in Assam, continues to be unresolved. If you go to Assam, these complicated legal languages are now part of ordinary people's parlance. Ordinary people will talk about linkage, family tree, legacy, etc., etc. This is the presence of law in this context. There is excess of law. And excess of law, in my assessment, tentative assessment, is doing two things. One, it is providing a veneer, an appearance of legality. Because there is so much law, this must be a rule of law situation. Ordinarily, many people will tell you that who are sympathetic to the process, that this is being governed by law, right? So law is providing a veneer of legitimacy, a veneer of legality, which perhaps connects to many of these post-partition debates. The other is, and I fear that law also is mystifying or obscuring the tragedy which is unfolding. So the debates around detention centers, for example, quite often fall on the question of, is there law to do this or not? What does the Foreigners Tribunal say? And I think we should all be worried that these questions of humanity and these questions of human tragedy inevitably fall to the question of legality when there's so much law. And there's a reason why there's so much law. And law is, as in small l law, in the sense of orders and executive decisions and letters and circulars. And third implication is what I call the culture of mass suspicion. Everybody, particularly if they are Bengali or Bengali Muslim, are under a suspicion of being a foreigner. And the Supreme Court order in the Sonowal judgment was an expression of that. In that case, the constitutionality of IMDT Act was challenged. The Supreme, and it's a complicated case, and maybe we can discuss it during the questions and answers. But what the Supreme Court said in that case was that the burden of proof to prove citizenship must fall on the individual because, and you can look at the judgment, I strongly recommend that you do for those who haven't, that there is practically an Islamic invasion from the East in India. There are millions and millions of infiltrators who have entered into the country, and this is a situation of aggression. And the state, under Article 355, is under a duty to protect its people from aggression. And since the state is failing to do that, we'll step in and we'll say, move the burden of proof, set up these foreigners tribunals. And this has remained a way of thinking about this problem. There's this mass suspicion that anybody and everybody is a foreigner or could be a foreigner. One anecdote, again drawn from the recent trip to Assam, is there's a legal debate around the question of res judicata in front of FTs. A same person would have many cases filed against him, they'll be declared an Indian, then there'll be another case in the FT against them. Sometimes a case has been filed against them in one FT, they declare them to be an Indian, in another FT they are declared to be a foreigner based on the same documents. So this person went in appeal in this situation to the High Court and argued that this is an absurd situation, it's unsustainable. I have like one FT who has declared me an Indian, on the same documents another FT has declared me to be a foreigner. And reportedly the High Court judge said that well, for nationalism and national security, we have to make sacrifices. So even if you have to prove your citizenship 100 times, you should be ready to do it for the cause of the nation. If this is the institutional culture where anybody and everybody is a subject of suspicion to be a foreigner, where anybody can be a foreigner, then nobody really is safe. Just to conclude, what does this story tell us about how the NPR, NRC, CAA debate flows out, beyond the question of constitutionality? For me, there's a clear link, Aymen's description about NPR, there's a clear link between what happened in the D-voter situation, where he said, an official Babu sitting in an office, looking at these lists, looking at names, on what ground, and then marking them as potential foreigners, or what 2003 rules say, suspected foreigners, doubtful citizens, and they can mark them as D. And the sociological implication, the expressive implication of a law like CAA is creating a culture of mass suspicion. There are certain kinds of people who belong to this nation more, the others may be foreigners. There's always a possibility. And when these elements come together, I think this would be an unraveling humanitarian disaster. Thank you.
I have to admit, I was hoping that the question of actual arguments on constitutional validity and legality of the CAA would probably be taken up by Sohrit or another practicing lawyer, so I could indulge in my favorite pastime of courtroom gossip, because 15 minutes is definitely not sufficient for an entire elaboration on what the challenges to CAA are, which so far in this panel we haven't dealt with. I don't think we have another panel on this. So I'm going to start with what I had originally intended, which is a kind of a report card of the Supreme Court, because my understanding of the conference is that we review the performance of the Supreme Court in the past year. So I'm going to just start with that and try to move through all of it quickly so that I can cover as much ground as possible. So forgive me for any lack of structure. I'll start with Sarbananda Sonowal, which Mohsin ended with. And that case, I feel, that case, you start thinking that perhaps we made a little too much of ADM Jabalpur, because there were a lot of other ADM Jabalpurs out there which we didn't give enough importance to. Sarbananda Sonowal, there's a Foreigner Act, there's a Foreigner's Order, there's a procedure prescribed for identification and prosecution of illegal migrants under those provisions. This was an act in the Illegal Migrants Determination by Tribunals Act of 1983 was an act specific to Assam. And it provided a certain procedure with certain procedural safeguards for this process. And I'll just point out what those safeguards are. In a sense, the burden of proof. Now that act is silent on burden of proof, but that's very different from the Foreigners Act, which under Section 9 specifically says the burden of proof is on the person who is brought before the court. And I'll come to the question of burden. It requires affidavits by two persons in the same police station area to say that we believe this person is an illegal migrant. That reference then has to be made to the central government. The central government in this case, under the rules, constituted screening committees. So the screening committees would receive these applications and conduct a preliminary inquiry on whether there is actual substance, because a lot of these applications may be moved by enmity. So the screening committee will evaluate whether there is prima facie evidence of this person being an illegal migrant. Thereafter, that matter will be referred to the Foreigners Tribunal for consideration, in which, since burden of proof is not mentioned like any process, the burden will, it was assumed in this case, and I feel rightly so, that the person who is bringing forth the material will have to say this is the material to indicate this person is not a citizen, and that person will then have to defend that. One person couldn't make an application with respect to more than 10 persons in his or her police station area. So this idea of taking an NRC extract and identifying persons of a particular community and filing applications against all of them, that's something that was specifically excluded. So you have to be living there, and having been living there for a while and knowing that I know I live here, this person wasn't here till 3 years ago, this family has just come in. Is the kind of complaint it's contemplated. It's not that somebody sitting in Delhi is sending an application saying all Muslims in this list I feel are doubtful, so please consider. There was prosecution prescribed for false complaints. So exactly for that kind of thing, where either on grounds of enmity or just communal bias you are filing applications, there's prosecution which is provided for. And there was an appellate tribunal. From appeals from the Foreigners Tribunal went to the appellate tribunal. The Supreme Court, in a bench in which Justice Mathur has given the opinion, 3 judges consider this the constitutional validity of this act, and the language that they use in striking down the provisions of this act. They say that these provisions, these procedural safeguards are difficult, cumbersome, and time-consuming. The IMDT Act and rules have purposely been enacted to give shelter to illegal migrants rather than to deport them. Of course, external aggression, Mohsin has already mentioned. They describe these procedural safeguards as innumerable and insurmountable difficulties in the Act. And they review the performance of the Act, and they say that as per the record, about 3 lakh cases have been examined by the screening committees, but there are only about 12,000 deportations ordered by the tribunal. So, in terms of efficiency, the figures speak for themselves that these people are not deporting enough, and the Foreigners Tribunal under the 1946 Act has a far better efficiency rate because it's deported far more people comparatively speaking. And again, the words used, hurdle, impediment, barrier, this is not a judicial decision. When I read Sarbanda Sonowal, that's an administrative authority speaking and saying that I'm reviewing the efficiency and this is not efficient enough. I mean, we've constituted these tribunals to deport people, and their deportation rate is not up to the mark. That is the sense that you get. So this is not a constitutional court examining question of rights, because citizenship is the right to have rights. And you are examining whether the taking away of the rights to have rights is by due process or not. And you are saying this is too much due process. Just get on with it and be quick about it. Then once this act cut down this is in 2005, the central government brings in another order by which, within the safeguards and the structures provided by Sarbanda Sonowal 2005, that is the first judgment, they say, okay, no screening committee, because they had said screening committee procedure is unconstitutional. So they say the tribunal will, before examining, consider whether there is a prima facie case of the complaint to even issue summons and call someone. So there are 2 levels of the examination. First, prima facie case of facts being made out, and then a judicial examination of the citizenship question itself. There, the court sits again, and this time 2 judges, Justice S.B. Sinha writing the judgment, gives the judgment saying that this is a violation of our first judgment, because again you are providing too much procedural safeguards, and this will defeat the purpose, and illegal migrants will never be deported. This is the vein, and now because we are reviewing 2019, we come to 2019, there's a judgment of Abdul Quddus, which is a question of orders under the Foreigners Tribunal, and whether if once there's an order under the Foreigners Tribunal, that person can or cannot be considered in the NRC. And the question of burden of proof, the procedure under the Foreigners Tribunal, although re-examined to say there is no appeal provided, it can't be that in a question like this, 226 is the only remedy you have, and the statute itself provides no adequate remedy. That is not permissible. So this time, again 3 judges, Justice Sanjeev Khanna writes the judgment, saying that this question has been already settled by 3 judges, Sarbanda Sonowal 2005, and by 2 judges in the following decision. And so we find that there is nothing wrong with this procedure. But again, when you read the reasoning, it's the reasoning which I find shocking, because he compares it to the Consumer Protection Act, and he says that this judgment under the Consumer Protection Act has already held that summary trial is not necessarily a violation of natural justice, and summary trial can also amount to procedural fairness. So just the fact that citizenship can be put in the same bucket as consumer protection in terms of evaluating whether this is adequate procedure before declaring someone to be a non-citizen, I find shocking. Then, of course, Aymen also mentioned that the 6A reference is pending. So just a couple of lines more on that. One of the questions pending before the 5 judges bench in 6A is whether, because 1971 and this reference order is in 2015, and so they say that over 40 years have passed, and so even people coming after 1971 have resided in India for more than 40 years. So what becomes of them, and what obligation do we have as a state towards persons who have been resident in the country for over 40 years is a question that has to be decided, and that's before the Constitution bench. Of course, the dates themselves are under challenge, 1966, 1971, whether they can be separate dates for the state of Assam. Assam Accord, in fact, which I find to be a fascinating piece of paper, because it's an agreement between a sovereign government and a protesting student body on a question of citizenship, promising to deport some other person. So it's not just we will delay your examinations. That's not that kind of agreement. It's an agreement saying that we will identify and delay. So if it's affecting the rights of third parties. So that Assam Accord I find to be an absurd piece of paper, to be honest. But once it comes into section 6A, then Assam Accord has its basis, and 6A itself under challenge in this bench. Now, as you all know, the NRC exercise has been conducted entirely on the basis of whether you can prove your relationship to someone who came before 1971 or not. But if 1971 is a date which may not be constitutionally permissible, then what becomes of this 500 odd crore rupee exercise that has been undertaken? What becomes of all the emotional hardship? There have been suicides, there have been imprisonments, there have been detentions. What becomes of all of that if 10 or 15 or 20 years later the court decides in hindsight that this was all unconstitutional? So when Justice Gogoi was the Chief Justice and the master of the roster, for him to have taken up on priority the execution of the NRC as an administrative agency practically, instead of his judicial function of considering this the question of constitutional validity, and even 3A validity is referred to 5 judges. So 1987, 2003, these dates are also subject to challenge. So without deciding those, how can either an NRC or an NPR proceed? And then on the question of the Supreme Court acting as an administrative agency, now the role of the judiciary and its boundaries in terms of what is its judicial function and where it's outstepping the bounds, I feel comes out more starkly in the Assam Public Works orders that were passed on a day-to-day basis. And I'll give some of those orders: appointment and transfer of officials conducting the NRC. Deployment of paramilitary forces, for instance, in the 2019 elections, they said that we can't spare, Election Commission said we need all paramilitary forces in the country to conduct elections. They said we can't, you are trying to stall the exercise, there is some oblique motive here, we are not going to spare the paramilitary forces who are engaged for the NRC exercise. Qualification or appointment of foreigners tribunal, because under the 1983 Act, they had to be retired judges, or for the appellate tribunal, they had to be hired high court judges, retired high court judges. Here, they set the qualification for appointment to foreigner tribunals, which is a lawyer of 7 years standing. I mean, if I was in a law firm, a lawyer of 7 years standing would probably not even be reporting to me, and I am not so senior in the profession. So just the fact that they are doing this and the attitude with which they are coming to it these things I find deeply problematic. Reports were submitted in sealed covers, where the Attorney General and the Advocate and the Solicitor General are excluded from the proceedings to say this is strictly between us and the State Coordinator. And orders are passed saying prayer A and B of his report are allowed. And nobody in court knows what prayers A and B were. There is no hearing. The bench assembles, dictates the order, and rises. And at the beginning and the end of each of these proceedings, people are left saying, I have an application, I am here for, and no hearing is granted. Then, so now just quickly, because I don't have much time left, I'll skip some of the other, also application for early hearing, which they said we don't believe an early hearing in the Constitution bench matter is necessary. So because that's the least on the priority list. Because Justice Swaminathan mentioned Justice Narrain. So there is what I call the curious incident of Justice Narrain on the NRC bench. And if you remember that phrase from I believe from Sherlock Holmes, where Holmes says, Watson, did you notice the curious incident of the dog in the night time? And Watson says, but the dog did nothing in the night time. And Holmes says, that was the curious incident of the dog in the night time. Also, Justice Swaminathan mentioned that I will agree with him on under-inclusion, that the state can't be questioned on under-inclusion. I agree with Justice Swaminathan entirely that under-inclusion as a doctrine does not leave subject to challenge anyone who is left out of a step which is taken towards granting benefits, because it can never be everybody at the same time. However, I would like to point out that the doctrine of under-inclusion so far has been laid down by the Supreme Court in the context of matters of economic policy. And the reasoning given in each of those decisions is that the state must be allowed room for experimentation in matters of economic policy, because they can never address all questions and give benefits to all persons at the same time. In a question of human rights, and particularly the right to have human rights, I would beg to say that perhaps the doctrine of under-inclusion cannot so readily be applied. To say that, okay, they may have been left out, we'll consider them another day, it might not be the same in the same bracket. Justice Swaminathan also mentioned Mr. Harish Salve and his argument. Now, I have great respect for all seniors of the courts that I practice in. But the argument that Mr. Salve made in that interview, that so Muslims are saying that we will be left out of the NRC in any event, they have a problem with somebody else not being being granted citizenship. So we may be deported. Why is that person not being deported is their challenge. So, and he said that this is the case of complaining that why does my brother's beer not have a rat in it. So just first, of course, the crudeness of it I'll brush over. But I think this is missing the fact that if you look at the politics of it, the BJP will never have the political capital to conduct an exercise where any person other than a Muslim in this country will be excluded purely on account of not being able to prove their citizenship. If something like the NRC in Assam was to be conducted in the rest of India, where 20 lakh persons in one state have been left out, of which more than 70% it is said are non-Muslims, and that is conducted anywhere else in the country, the BJP will be reduced to the status of a regional party by the time the next election comes. They will never have the political capital to say that Muslims will anyway be excluded from citizenship. How can they object to somebody else being granted citizenship? That is because if somebody else is not granted citizenship, the Muslims will not be excluded. That is the political reality of this country. And lastly, on the actually not lastly, just two more points. One on Akhand Bharat and the history of India. So just and purely on the question of under-inclusion, because we can't question the policy priorities of the state. That is settled law. But once the policy objective is stated, then that can be questioned. And if you read the statement of objects and reasons of the CAA, you will see numerous references to undivided India and our obligation towards the persons of undivided India. And then when you notice that Afghanistan, which was never a part of undivided India, is included, but Burma, which was in fact governed by the Government of India Act 1935 and only separated from India in 1937, which is facing a refugee crisis and a genocide which the world is talking about today. If we ignore that and talk about our obligations towards Indians or Indic populations of undivided India and a civilization obligation and talk about Afghanistan, then I feel that on the reasoning you have given, having no nexus to either the history you are citing or the object you are seeking to achieve, which is giving refuge to illegal migrants, your logic breaks down. And I feel that's still a subject matter that can be challenged under Article 14. And now lastly, Swaminathan also mentioned that there is a sense of restlessness that comes about when Vande Mataram is sung, although Jana Gan Man, everybody stands up in attention. So I will just briefly mention as in conclusion the last of the national songs or the patriotic songs in this trilogy, which is Sare Jahan Se Acha. And in Sare Jahan Se Acha, there is a perhaps often not fully understood line, which is Aabe Raud de Ganga, wo din hai yaad tujhko, utra tere kinare jab karwan hamara. And that literally translated means, oh waters of the river Ganges, you remember the date on which our individual caravans landed and stopped on your banks. And that's a national acknowledgement of the fact that we are a country of immigrants. There is no Indian nation, and the idea of a nation and a state, there is no Indian nation that precedes. We are not a linguistic nation, we are not a religious nation, we are not an ethnic, cultural, we have no other sense of identity other than our shared history, our shared freedom struggle, and our shared belief in the state. So there is a national acknowledgement that we are a country of persons who have gradually assembled to form this country as a country of immigrants. लोग साथ आते गए और हिंदुस्तान बनता गया.
Thank you to all the speakers for, I think we'll all agree, it was a very stimulating session with a range of perspectives which were really put on board. And I think to me what captured it in some ways was many things, but I think Mohsin's invocation of the idea of twilight citizenship and how we are seeing the issue of citizenship through new lens, and that's really the crucial point. It links up in a sense also to what finally Pasha concluded with, which is the idea of whose citizenship is under doubt today, which links up to I think Aymen's point about the idea of the doubtful citizen. And in a sense, all three presentations, I read it as a respectful dissent from Justice Swaminathan's presentation, and saying that, or maybe a footnote to his presentation, saying that, a footnote which in a sense maybe overwhelms the main thesis, which is to say that the key issue here is really the question of how citizenship is under challenge, under question. And I think Pasha's invocation of the idea of the right to have rights is critical, and that may be a response to the Article 11 question which Justice Swaminathan raised. Article 11 basically says citizenship is left to Parliament to decide. So it's a matter of executive discretion. But the question is in a matter of executive discretion, can you violate the fundamental tenets or the thinking or the Constitution itself? And the point really is this. When we go back to the right to have rights, the invocation is really Hannah Arendt's book. And why does she call citizenship the right to have rights? And for that, I want to just take you to one example which actually Malvika can speak better to, but I'm just going to paraphrase it since she's not here, unfortunately, on this panel. And about a case which came up in Bangalore a couple of days ago, where there was a couple of slums where demolition began on the ground that the slums were inhabited by Bangladeshi immigrants. And if you look at the police notice in that particular, which was put forward to justify the slum demolition, it basically said that the Bangladeshi immigrants here, which has been the basis of which has been found on the basis of a WhatsApp forward, which has reached international status. That's broadly what the notice said, based on which the demolitions were carried out. Right. So the question is, the right to have rights is in some sense we can look at it within the dimensions of the Constitution and say that yes, non-citizens have rights under 14 and 21, but in reality, what the law has done is created what you rightly called a culture of fear, a culture of impunity, a way of taking forward the deprivation of rights of people which you can't otherwise do under the constitutional framework. So in a sense, it's a question of how the law or legality overwhelms the constitutional framework, or the pretense of legality overwhelms the constitutional framework. So in a sense, the fundamental issue we're really faced is, how are an entire grouping within the country deprived of rights based on mere rumor alone? To give you a sense of the High Court proceedings, what happened in court is the challenge was posed was really this, saying that what is the basis on which these demolitions have been carried out? And the government, the advocate for the BBMP, the advocate for the police, all of them said that we had nothing to do with this demolition. So the question is, who was behind this demolition? And how did this demolition really happen? And the way the Chief Justice put it, he said it seems to be an invisible force which has carried out the demolition. And our colleague responded by saying it's an invisible force dressed in khaki. So the demolition really was, to believe it or not, was based on a WhatsApp forward. And constitutional rights were deprived, people were deprived of constitutional rights on the basis of a WhatsApp forward, which indicates the truth of the proposition that the law's implications are sociological. The law's implications are beyond the mere question of legality. And we're seeing the implications of the law beyond the question of what the law actually does. And that's the biggest danger which we face in terms of the entire enactment of the CAA and the climate which have been created in the country today. And perhaps I'll just end and we'll take it up in terms of maybe questions and answers from the panelists. Is in terms of the entire debate we're under inclusion, right? End of the day, is this a question which can be determined within the narrow frame of the test of reasonable classification under Article 14? Or do we have to have a broader frame to think about this? Again, my reference will go back to Aymen's point where he referred to fraternity and the preamble. I'd say Article 14 as well. We can't restrict Article 14 to the classification test. Article 14 is a preamble of promise. It's there in the preamble of the Constitution. So which means we have to think of Article 14 beyond the question of classification alone. And then what I'd say is I think the understanding of equality or the discovery or the rediscovery of the Constitution has really been, again, what Mohsin's invocation of the protests on campus or the sit-in on campus or the protests around the country. I think people have spontaneously understood that the idea of equality in a substantive sense is what is being violated. So I think what is our hope, what is our prayer, what is our expectation is that the Supreme Court also understands that it's really beyond classification. It's really a fundamental and substantive violation of the principle of equality. Again, if we go back to the Constituent Assembly and we go back to the Objectives Resolution, when Nehru speaks in the Objectives Resolution, he says it's very important that we understand this resolution not in a dry, lifeless sense as lawyers do, but in a substantive sense. We understand the spirit and the passion underlying the resolution. So in a sense, what we need to understand is how do we understand the CAA? Not in a sense of mere classification under inclusion alone, but in a more substantive sense. What is the damage or the danger it does to the very idea of the nation or the idea of equality under the Indian Constitution? That's a question which is really before us. But I think I'll stop with that. But I think I'll leave it to people to ask a range of questions. Because also I think what the speakers have done is expounded on certain key dimensions of the debate. And again, there's a lot to be said on each of these technical dimensions which we really need to understand in a deeper sense. And we're very grateful that our speakers have really got a certain level of ground level experience to shed light upon various dimensions of the debate. And without further ado, I'll leave it to you to ask them your doubts and questions. Yeah. Sure. If you guys could just, maybe we'll take 5 questions. Maybe you can state your name and then go for the question. Professor Mustafa.
Thank you, Arvind. So, in the context of CAA, we are seeing in determining constitutionality, you have to just look at whether the parliament has jurisdiction. And you have to just look at whether it violates any fundamental right. If this is what the law is, why IMDT was struck down? Because it was within the jurisdiction of the parliament and it did not violate any fundamental right. And if Sonowal goes, then this whole process should go. You cannot be having one rule to determine the constitutionality in one case and another rule to determine the constitutionality in another case. I concede the point that we live in the post-truth era and logic and truth no more really matter. But nevertheless, I am really at loss to understand how our courts are looking at questions. The court which was importing due process post Menaka Gandhi is now saying why you are having due process. And the Chief Justice is on record to say why such a small number of deportation. He was willing to punish Chief Secretary of Assam for this. So if, that's why I am saying that the government or the current government in particular cannot be blamed for the mess in which we are. It is the judges of our court, and of course the judges reflect our society. So, so I really don't know. I think in 2015 or so, I sat at Harvard Law School that I don't mind really if India can be declared to be a theocracy like Britain, with adequate protection of rights of all people, but all Indian students, immediately disagreed with me and say we don't want it. But it seems at least our judges want it, if you look at their cases. So if that is the reality, then we must accept this reality. We can't be doing anything about it.
Yeah, thank you for this. Was a really excellent panel. I have a question for Mr. Pasha. Could you share your thoughts a little bit on the challenge to the 2019 amendments to the Foreigners Tribunal Order 1964? The amendments pertain to the appeals process, the Foreigners Tribunals. Say, if you're excluded from the NRC, then obviously you would appeal to the Foreigners Tribunals. And my understanding is that the amendments allow the tribunals to dismiss an appeal without even hearing the appellant. And it's currently before the Supreme Court. I think the case is being challenged before the Supreme Court, which, I mean, that's just one of the challenges. There's other complications. And yeah, if you could share your thoughts on that.
Yeah, thank you. I just want to say this is very important that we understand the various perspectives offered. I just want to say, Arvind, that I took Justice Swaminathan not as, I think as he said at the beginning, and I really want to commend your presence here. I also want to say, since ADM Jabalpur was mentioned, your point which you said in jest, but historically it has been true that in ADM Jabalpur, 9 high courts in this country issued habeas corpus. It's the Supreme Court which failed us. We are clearly in a time when the same situation is happening. But to go back to what Professor Dhanda said yesterday, I think it's a time of what can we do and not just look at despair. We are a large country, we have many institutions, and collectively there are things to be done. And I want to commend, you mentioned the Ulaganathan judgment, which at the High Court level, I think does something. People interested in refugees and migrants are deeply enthused by some of your interpretations. And as you know, there are also some people who pointed out problems in the way you approached Ulaganathan. But to the extent that High Courts in this country, and Arvind's example of the Karnataka High Court having stepped up, there's a real sense that there's that diversity is showing up in different sort of responses. And I think this is really crucial for us to all think of it. And I take your point when you said you have to understand the mindset of what is motivating this, where is this going. I share Arvind's concern, all of us who are in Bangalore, this idea that this invisible force can happen is happening precisely because of this larger climate that is being created. It is making people just draw into this idea that there are all these infiltrators amongst us, and then anybody, you don't have to be, whatever be your ideology, you should be concerned about just basic law and order. If this can happen in the capital of India's Silicon Valley, that people can just come and demolish places, and nobody has a response. And the response of the BBMP, of the government, is this is an assistant engineer who went, right? And the fact that these people came without uniforms, pretty much like a thug group, is deeply concerning. If you're concerned about law and order in this country as a whole, that's what is at stake. On your point about what is the mindset, I do want to say, I think you mentioned in the assembly also there were these presences. So I think that's becoming very clear to us. This is Professor Mustafa's point, that these are age-old struggles. There's been, but I do want to say that the vision that you are saying of Akhand Bharat, of this, was even in the assembly a minority view. Right? And the framers at that time came together. As we know, there were many people, even within the Congress, who shared parts of that element. But Patel and Rajendra Prasad disagreed with parts of that view as well. And we need to recognize that people in the majority community who distance themselves from some of the other sort of elements. And I think that's important to hold on to. So I think this is a real contestation. And then I think how we go forward will depend on what not just High Court judges, but individual academics, students, citizens now respond to and how we take it forward. I just want to get back to Aymen's point. And Aymen, I think you raised a good point about what, and so going to another, so there are judges, High Court judges at various levels, what are state governments doing, how are they doing? So we are having these legal questions of what is the ambit of Article 131, so can they raise it and go there? But leaving aside the courts, I think what you said is quite powerful in the notion of what is the imagined role of the Indian state. Right? And again, we know that this is an area, we had the federalism panel yesterday, I think Alok and Malvika spoke about how our original conception of federalism has clearly changed. And in 1956, with linguistic reorganization, some of the framers themselves conceded that that vision would have to change at that time, and people who study federalism prior to 2014 would have told you that the change in federalism in India has happened not because of the legal and constitutional status, but because of the political forces that have shaped it. So we seem to be at another moment now when states are trying to assert their role, and how do they take it? So I think you point us to interesting examples of provision. So 355, since you mentioned it, in comparative constitutional circles, when you read it, and this is what our Home Minister has been alleging, right, that he will not hesitate from using the full resources of the Union to enforce these laws. So when you look at 355, I do want, and this is where comparative federalism becomes a bit important. When you look at 355, it seems to say that the Union can send in forces. But the history of that, there are exact provisions both in the US Constitution and in the Australian Constitution. And these are federations which are quite different from the Indian federal model. So the idea there was, it says the duty of the Union, right? So our Home Minister may think that he can send forces in whenever he wants to, but the actual origin of those provisions in the comparative context was to empower states. So I think your idea of saying, how do we think of what are the roles of individual states? And how do we take even constitutional provisions, but perhaps look at their constitutional history and their original history of where they come from, and then marshal that to make a different argument is a very powerful idea. And I encourage you to sort of pursue this forward, whether you take it from fraternity or you take it from the provisions that you're looking at, but they're different histories, and how they can be marshaled and how we should be careful, how we interpret them and take them forward. So I just want to commend you for that, and I hope you're continuing to work on it.
Hi, my name is Siddharth, and I had a very similar question to what Sir had regarding the role of states. So it's addressed to Mr. Aymen Mohammad. So with regard to what, you had talked about how states should have a greater role in interpretation of the Constitution. So with regard to that, what the resolutions passed by state assemblies, how constitutional are they in light of Article 258(2)? And also, does this itself mean that this becomes a ground for the center to claim that there is a breakdown of the constitutional machinery in the state when state assemblies pass such resolutions? And secondly, with regard to Article 131 petition, how do you think that's going to play out, especially because the CAA is not within the legislative competence of the state assembly? So how much of a scope under 131 does a state have to challenge the constitutionality of laws where in the first place it's not legislatively competent to enact those laws, or it falls within its field? And secondly, the law doesn't necessarily affect the relation between center and state as we know it. And my last follow-up to this entire debate on the role of states is, if it cannot be done through resolutions, if it cannot be done through a direct court challenge, how much scope does a state have to interpret the Constitution? Or was it a deliberate idea of the founders to restrict the scope of states to even interpret the Constitution by not recognizing that at all explicitly?
Question is pressure in my mind. I'm going to start with that. On the question of whether states, what they can interpret is restricted, I mentioned this in the discussion also, that every time a district magistrate issues a section 144 order, he or she is interpreting the constitution. So we have to get out of this idea that constitutionality is something that only judges decide and all of us follow it. If you were to look at any judgment, the rhetoric of those judgments is rarely corresponds to the orders, effective orders that those judges pass. But if you were to look at electoral mandates and how they impact how your DPSPs are implemented or how your fundamental rights are protected, it's an area that a lot of it has been written on about. Similarly, I don't think only state entities get to interpret the constitution, citizens do it too. Not all. Because we assume that regional parties have created at least de facto federalism in the sense that the power imbalance is improved. But I think we have to be cautious about regional identities because especially in Assam's case, sub-regional identity was always xenophobic, it was ethno-fascist, and it persecuted not only Bengalis or Bengali Muslims, it created little nationalisms of all sorts, including Bodo nationalism, which again came after Bengalis and Bengali Muslims. So we do need to worry about what sort of federalism we imagine and what sort of sub-regional identity we recognize. And I think we have to be very conscious of the fact that a powerful state does not by itself mean that you will not have an NPR or an NRC or a CA. Let's remember that it was Assam that created this. It was Assam, literally Assam, that pushed the NRC again and again. So I think it's very important for us to think about what sub-regional identities and how they inform federal conversations and conversations at the union level. On Article 131, again, there's not a lot of litigation where states have gone and challenged things by the union. But my limited opinion, because I have never actually participated in litigation, I don't understand how courts operate. Apparently, neither do lawyers anymore. So Article 131 does include determination of rights. Now, this is not the same as competence or power. It's an assumption that states do enjoy certain rights or at least have a standing before court to question determination of rights. Now, on the question of either enforcement of CA, NPR or NRC, I think there is a very strong possibility of questioning the fact that there is an implicit infringement on the state's right to, or the state's duty to protect public order. But that's just my academic opinion. I think on the question of 131, the court has an opportunity to expand and look at determination of rights in a more comprehensive manner. But I'm personally not very hopeful.
I know nobody asked me a question, but I just quickly wanted to. Sorry. Wanted to respond very quickly to what Professor Mustafa said about the Sonowal case and about how in that particular case and what Nizam was also talking about. I suspect, unfortunately, this is ingrained in our institutional culture. Of course, there are people who have argued it. And the most distinctive example in the context of citizenship is what happened in the detention centers petition. In full disclosure, I was assisting in that petition. There was special monitor, Harsh Mandar from the NHRC. The report came out a year and a half ago, recorded terrible conditions in detention centers, children, women being detained, practically forever, in perpetuity. And when ultimately a petition was filed in the Supreme Court, it went in front of Chief Justice Gogoi's bench. And the argument, among many other things, was that you can't have imprisonment of people in jail complexes forever. And that obviously violates Article 21, among other provisions. And the first thing the Honorable Court did was to say, all right, how many people are there in detention centers? And there were a bit over 1,000 people at that time. And then the judge said, how many people have been declared foreigners? And obviously thousands have. The first step the Honorable Supreme Court did was to reprimand the government and ask them, where are all the others? Why are they not in detention centers? I want the government to respond. So a petition which was filed to ask for fundamental Article 21 rights immediately turned into potentially a proceeding of mass incarceration. It was right there. Well, there were a series of events which happened, including the named petitioner stepping out or being asked to leave, and lots of other dramatic things it's covered in the media. But I think this is indicative of what all these proceedings are always in the verge of happening. There's always this moment, I'm sure lawyers here will tell us, that there's always a thread that you file a case and it'll just be turned upside down and be used precisely for the opposite things for which the petitioners have gone to the court. And that has now practically become part of litigation strategy. You know, almost every lawyer I talk to, one thing they are worried about is, are you sure you want to go? Because this will be turned around and the opposite thing may start happening. And that is something I think institutionally we should be worried about the court.
So, on the question of foreigners, tribunals and 2019 amendments, so because the 2019 amendment to the foreign tribunals orders is deeply problematic in some of the things like you mentioned, that the tribunal has to, if it finds merit in the appeal, it will issue notice to the appellant and to the district magistrate to respond, which means that your citizenship may also, after you file an appeal, may be decided without a hearing. So, and again, this is that same point of summary trial and whether a hearing is required, natural justice, for a right of this nature, for the right to have rights. But there are a lot of other issues also in, to do with these foreigners tribunals, because I mentioned the qualifications, that 7 lawyers of 7 years standing, retired bureaucrats, etc. 200 such tribunals have been constituted. They have been very, very hurriedly put together. The order that the Supreme Court passed was they should be given a 2-day training session to bring them up to speed with the regulations that they have to apply. So we are talking about people who may not even have judicial experience, who have 2 days of training and have been recruited hurriedly, because after the NRC exercise was the NRC was published and before the hearing start, they needed tribunals enough to hear 2 lakh, 20 lakh applications. So hurriedly convened. It's the way the whole thing has processed is actually deeply problematic. The 2019 amendment also says that if a foreigner's tribunal has earlier already found you to be a foreigner, then you no longer have a right to appeal. So, and strangely enough, the converse is not there. So if a foreigner's tribunal earlier has found you to be a citizen, it's not as if you must of necessity be in the NRC. You can still be left out of the NRC, and you can't go to the foreigner's tribunal and say that res judicata. That is not a provision that is provided for. So then there is a question that I have. I mean, I have no real answer to that question, but the Citizenship Amendment Act itself, 2019, in section 6B3 says that on and from the date of commencement of this act, any proceeding pending against a person under this section in respect of illegal migration or citizenship shall stand abated on conferment of citizenship to them. The NRC exercise is also a proceeding under the Citizenship Act. So if under the CAA an exemption is given to any person covered by the CAA from proceedings which are pending, so that's the political worry, right? That in between the NRC and the CAA and this deportation, you insert this new act and this amendment and this exemption from prosecution, which means that the proceeding, NRC related or before foreigners tribunal against you, will abate the moment you apply for citizenship, saying that I'm a person from one of these countries and one of these, and that's the worry, because there is no there is no bar that you had earlier said that you are a citizen and you had applied for citizenship under NRC. Now this route of CA is closed to you, should be, to my mind, the understanding, but in fact it's the contrary, because there's an exemption from prosecution. Citizenship Act section 17 says that any person who lies or misrepresents in the context of a citizenship related proceedings can be liable to 5 years imprisonment and 50,000 rupee fine. That is also proceeding under the Citizenship Amendment Act. So when you talk about exemptions from prosecutions in respect of citizenship, you cannot perhaps even be prosecuted for having filed an application in the NRC. So these hurriedly constituted tribunals are hearing cases on the basis of these really problematic procedural rules, with a really deeply problematic substantive law which is applicable, which gives you this alternate route to come out of an NRC exercise based on your religion. Just one thing which I forgot to mention, I'll just take a minute on that. This very day last year, Arvind had in his presentation on constitutional morality discussed the Ambedkarite idea of a constitutional morality, and his paper on what an Ambedkarite constitution would look like. So in fact, I must confess, I went back to the recording of that and heard it while drafting my application challenging the CAA, because, and this is, I feel, not spoken about enough, that constitutional morality is actually should be the bedrock of challenge to the CAA. Because while we talk about ideas of, the preamble, etc., what it all relates to is an Ambedkarite idea of constitutional morality as a tool in the hands of a minority against the oppression of a tyrannous majority. And in all of those cases where it has been mentioned, there were several other grounds also, but I feel that this is really the case where whether the Supreme Court and the constitutional Ambedkarite idea of constitutional morality will withstand and deliver when it's actually called to deliver, something which will be tested in this case, in the CAA challenges. Because leave aside everything else, manifest arbitrariness, all of those doctrines which have evolved, all of them may be invoked, but constitutional morality actually, if all else fails, purely on that ground of constitutional morality, I feel that CAA should be struck down as unconstitutional.
We'll take one more.
My question is for Justice Swaminathan. I think that it's possible for the government of the union as well as the government of the state to take the same position about Sri Lankan refugees because of the success of the narrative building exercise of the dispensation at the moment, which is that they've made it seem like refugees or stateless people will be saved by the conferral of citizenship. And so, of course, the union and the state will both come and argue that citizenship can't be granted to these people because the very idea of citizenship has been built as an opposition to a foreigner who is illegally in India. It's a binary that is created by the Citizenship Act. But, so with respect, I feel that the question, if it is really about refugees, must not go as far as citizenship. It must be union and state, what are you doing for refugees? You can just grant them asylum. You can just give them a long-term work visa. These are all options validly recognized in international law that most countries in the world are, at least most refugee-friendly countries in the world follow. And that's a good way to welcome back refugees. But the present dispensation has so successfully constructed this narrative that a refugee can only be given protection in India if you confer citizenship, but that's several leaps in terms of legal constructs. So I feel like that is why both governments are able to take that position, and I wonder what your thinking is on why they make that leap and why courts are allowing them to make that leap. There are several intermediate protections that are possible. Thank you.
I'm sure they are around so you can have a great interaction with them during the rest of the period. Thank you.